are different from the actual facts that occurred, so we obviously have a dispute there. And in the statute, it says,
Are you talking about 3.190?
yeah.
Here, I'm looking at it, right here.
Okay, so it says,
3.190, C
D.
and 4, right?
C4D.
Right, but C4, there are no material disputed facts, and the undisputed facts do not establish a prima facie case of guilt against the defendant. And then D says the state may traverse or demur to a motion to dismiss that alleges factual matters. Factual matters alleged in the motion to dismiss under subdivision C4 of this rule shall be considered admitted unless specifically denied by the state in the traverse, which they did. They went through it in, sort of as if it were a civil case, and said admits paragraphs 1, 2, 3, 6, and that's noted on yours. I actually printed it instead of using the computer.
I did something.
And, yes, but they did specifically deny paragraph 7 and 8. And the 1, 2 last sentences of paragraph 5. So, and they have denied it with sufficient specificity as required by the rule.
Yeah, I guess my,
Is that, I'm sorry, go ahead.
I was just saying my argument in response to that would be that I don't believe that it's pled with specificity, that it doesn't fully address the facts in which I've put out into my motion, my C4 motion to dismiss. And furthermore, it goes further to state facts that occurred prior to the crime actually happening. So if we had a crime that allegedly occurred on April 29th of 2015, a lot of the traverse that's filed deals with issues and incidents that allegedly occurred prior to that date even happening. So I don't believe that in response to my motion to dismiss that it's pled properly to the material facts that I've alleged with specificity.
I think that the paragraph 6 and 7 speak directly to what appears to be the gravamen of your motion to dismiss, which was that no one had spoken to the child, but because it's not mandatory for someone to have spoken to the child in this particular, under this particular set of facts to, in order to have the traverse nullify the motion to dismiss.
But we're saying that there was a false report made to the Florida Abuse Hotline. If that report was never investigated, how it were properly investigated by speaking to the child to see, hey, these allegations are true or no, they're not true, how can we move forward on it? That's what my argument is. How do we move forward? We don't know if it was a false report or not because nobody spoke to the child. Nobody actually talked to her to see if what was said in the phone call on that day, the day in question, April 29th, 2015, without speaking to her about what my client called in about, there's no way to prove that this report's actually false.
Mr. Shandy? Thoughts that you would like to?
Well, I think I put it in my motion. I added additional facts that were not in the defense's motion to dismiss. In addition, the argument they're making would be somewhat similar to a domestic violence case or attempted murder where the victim doesn't testify, but yet the state puts the whole case on, and there's still sufficient evidence to prove it at trial. They're really making a JOA argument or an argument in terms of guilt for a jury. I've alleged, the state, on behalf of the state, has denied multiple paragraphs in their motion and added multiple paragraphs of additional facts which are relevant. Clearly based, most of them are based on the defendant's conduct.
prior to the call that was actually placed. And Judge, there was a second charge for cyberstalking, which the state hasn't filed on. So you can't just bring in all these things that happened prior to April 29th, 2015 to prove that my client was harassing him. The statute is very clear in that we have to use the filing of the false report of child abuse on that day and time, how that call particularly harassed the alleged victim, which is the father of the child. So honestly, it doesn't even really come under Chapter 39, because Chapter 39 deals with the child itself. The child didn't even know that there was a call placed, was never spoke to, has no idea if this is even going on right now. So it's honestly not even in the right chapter.
Ms. Burgess, after considering your motion, and I did do some research on some case law this morning, and reviewing the rule a couple of times and carefully reading both yours and the state's motions, or your motion and their traverse, your motion to dismiss is denied. So you will be back on Thursday, right? Because you're on the trial record. You're called in on Thursday.
Correct. Yeah, but I thought Mike's email said something about if you were further down. I'll read it.
I got the list.
I'll be counting on Thursday, but I will figure out how to be there somewhere.
Is Mr. Ross associated with you in this case?
Yes,
Barbara?
sir.
Maybe he can meet with you on your email.
Yeah.
Okay, thank you. Thank you very much.